Lordship, I beg to mention item number 19. I'm appearing on behalf of Mr. P. Nongbre.
Yes, sir.
He's indisposed.
You are for?
Petitioner.
Petitioner.
No objection, Your Lordship.
On pre made by petitioner. This is matter of the 3 weeks.
Please, Your Lordship. I beg to mention item number 7, my lord.
7.
These are those Nehu matters, my lord. I'm praying for 2 weeks' time. This Paul is still indisposed, my lord.
Who's for the?
I have informed the other side,
Have you informed them?
my lord. I have informed.
These Nehu matters.
7, 8, 9, and 10, my lord. They are connected matters.
On pre made by the petitioner. Not objected to by the respondent. You are here, miss?
Yeah, Your Lordship, for item 11, connected.
Any objection?
No, for item 11, Your Lordship.
Yes, any objection? On pre made by the petitioner, not objected to by respondent. This is matter after
2 weeks.
2 weeks.
Please, Your Lordship, I beg to mention item number 6. The counsel for the appellant is out of station.
Yes, Mr. Shulai, you are here?
I am not there,
Yes,
Your Lordship.
Appeal. Criminal appeal.
Lordship, let it go. Mr. Senkupta is
On
there.
pre-made by the appellant, this is matter after 3 weeks.
Duly obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 20 and 21. Your Lordship, the matter is still pending before the...
So,
Let it come after 10 weeks, Your Lordship. Because on 19.4 also the other respondents are yet to file the affidavit before the Honorable Supreme Court. So let it come after 10 weeks, Your Lordship. Both this matter.
on pre-made by the parties, indicating that the matter, related matter, is still pending before the Supreme Court. Matter is adjourned. Let's the same after.
10 weeks, Your
10
Lordship. Only that liberty may kindly be accorded, Your Lordship.
Let's see after 10 weeks. However, in case the matter before the Supreme Court is decided earlier than the date fixed, liberty is given to the parties to
Make a mention. Your Lordship.
mention.
Apply, Your
I
Lordship.
oblige, Your Lordship.
So, good name, something.
On supplementary cost list, item number 1.
My lord, here, my lord,
weeks.
Yes. No, sir. Much obliged. Please, Lordship. Lordship, I beg to mention item 12, Lordship. It's, the doctoring council is having some personal engagement with the Lordship.
12. I think this court has indicated that no further adjournment will be given here. 2014 matter.
Yes, Lordship. Mr. Paul is having difficulties, Lordship, today. He's not available.
On pre-made by the petitioner, this matter after 1 week.
Lordship, if it's after 2 weeks, Your Lordship. Next week, Mr. Paul is having, he's not available, anything, Lordship. Your Lordship allowed 2 weeks.
2 weeks.
Similar prayer for item 17, Your Lordship.
This matter, Lordship, has been heard,
Has
Lordship.
been heard.
Item 17.
Oh yes, that
Our side also we have argued.
Only
What
my
you-
side.
Like only for the.
Oh yes,
only
Mr.
for
Hazara,
private respondents, Lordship.
what happened to you that day? We were waiting for you.
No, that day I was on the Lordship. I went home for 10 to 20 days. So today I will do my part because I am temporarily appointed. I have nothing to say. My service was extended till date. Temporary basis. I have no right. Unless this permanent was coming, according to that, my appointment is that till permanent appointee is coming, I will continue in this post. Only this much.
Okay, so we'll take up the we'll hear.
Yes.
You have argued. You have completed the
They
argument.
have completed the argument. Petitioner, our side also, we have completed.
Only my contention is this much, Lordship. Because till 2016 they are extending my post till date on the basis that till permanent appointee is coming.
So we'll take up the matter.
Yes,
Mr. Thank you also here.
I have only one small request, my Lord. Since this matter is being led by the senior counsel, my Lord, it would be better if he's here also, my Lord. It wouldn't look good on my part, my Lord, to just take over, my Lord.
We have no objection to that.
When the respondent, the private respondent
I understand, Lord.
has
It's
already,
a very fair submission.
yes,
also,
he has
been advanced,
already
my Lord.
conceded. Huh?
Very fair
Yeah.
admission,
So
my Lord. Very
what
fair
else?
submission.
And
also.
now the onus will be on the government
Government.
as to whether to renew. When is your next renewal?
Next renewal, the copy is not with me, my Lord. Till now,
It's
I am
it's an appointment of 59
government
days,
will
isn't
know
it?
59 days, my Lord.
On his, Mr. Karmi, on the basis of his admission, you check the records and see if perhaps, we don't know, his next extension is supposed to be maybe the next 2 days or 3 days or within a week.
Myself
Then you
also,
pass this orders.
Yes, myself
stop.
also I will try to obtain.
Stop.
This.
On premier with the parties, let's just matter to 2 weeks. I think within 2 weeks, the picture would, but Mr. Paul is not here.
My Lord.
Much obliged.
I'm obliged, my Lord.
Meet, please, Your Lordship. Lordship, I beg to mention an item number 14, Your Lordship.
14. Those home guard matters.
No, Lordship in this matter has directed us to file an affidavit bringing on record, Your Lordship.
Yes.
Yes, but Lordship, on the last occasion has granted us 2 weeks time. But Lordship, we just make communication to the petitioner. They are in Tripura, Your Lordship. So, Lordship, I require some more time, Your Lordship.
Yes, so these are those home guards, isn't it?
Yes, Home Guards, Your Lordship.
On pre-made by the petitioner, let's just matter to 2 weeks.
Highly obliged, Your Lordship.
So, Lordship, item number 13, it may be taken to the end of the board, Your Lordship. I am having some other matters here. End of the board.
It will come in due course. So why are you making
I am having one matter in this another board, so we have to-
exactly? As and when you are free, we'll wait for you. Don't worry. In the meantime, we can have a cup of tea here also.
Daily cost list, item number 1.
But I filed a miscase for intervention and impleadment, my lord. This is miscase number 5, my lord. Last week, my lord, I had filed another application, but I had withdrawn it because of the problem in the cost title, my lord. This case number 5 of 2023.
So who's to respond?
So I have no objection to this point.
On the last occasion, I had indicated, my lord, that in the suit below, I have filed an application for impleadment, my lord. But since all the records have been called here, so everything is stalled. And I am interested only in this particular issue, which is before your lordship, in this CRP, my lord. I'm not concerned with the main suit. It is only this particular issue.
But again, this question of lateral entry.
My lord, the reason being because
of the proceedings, I don't know whether.
Well, the problem is because all the records have been called here. That is the only issue, my lord.
Records have been called?
And if I'm not heard in this particular issue, my lord.
Lordships had heard us on the issue of maintainability and then called the records.
In any case, the proceeding before the trial court was stayed.
There was no judicial order, my lords, but the court wasn't proceeding in view of the pendency of these two cases. There is another revision petition challenging an order of rejection of a 711 application. If the suit proceeds, then my application here may become infructuous. That is one of the reasons why the court did not proceed with the matter.
See again, I think we have to, we have to look into the, we'll have to look into the status of, an intervention petition at this point of time, since admittedly the parties are not parties before the,
yes, ma'am.
In the main suit.
Let them file the objection. Notice will be issued. Let them file the objection.
Your grievance will be
against this particular injunction order.
May I also add that the pendency of this should not be a bar to proceed with the hearing on maintainability. Because if my lords hold that my revision application is incompetent, then all of this goes.
No, but then, see, now if he's allowed to intervene, and he'll also be part of the, the hearing on the issue of maintainability or otherwise, even on merit.
I don't think they would oppose the question of maintainability. At best, they will set up a...
I'm only concerned with...
Mr. Sen, you're putting words in there.
No, my lords, they cannot really have a questioning. They can't really question the competency of my petition. Their right is basically that they have been issued a license today by the government. I am the government who has issued a license to them. They are the fresh license holders. They cannot object to my petition.
This is your petition, isn't it?
Yes, no, not the miscase.
Yeah, not the miscase. I mean,
the main revision petition is my petition. I don't think they would ever object to my petition.
So basically, you'll be arrayed on the same side as Mr. Nongri.
No, my lord, we will be opposing each other.
Right.
We'll be opposing each other. They were the license holder. I am the license holder.
And yes, that is understood.
So which is what I'm saying, well, that can be decided separately. It can proceed together. But the maintainability issue can be decided before that as well, or at the same time.
Yes.
Lordships have it within a week's time, next Monday.
Let me be clear about this issue. I'm still confused about these things. I'm out of touch with CPC. I think Justice Thakur will be the best person to handle this case.
He has recused Mellis from this matter.
Anyway, that's beside the point. So let's look at this.
Yes.
The government has filed an application wherein you have impugned the order
of injunction, my lords.
order of injunction. Now the injunction is basically addressed against you.
So they had the respondents had been issued a license for operating the game of arrow shooting. That license had come to an end, so they were issued a show cause notice, and that license was seized. Assailing that, in a pending suit on a completely different cause of action, they filed an application under Section 94 praying for a stay of those orders which was issued by the government. That was made absolute by the court. A stay was granted. Questioning that stay, we are before my lords by way of this revision application.
Okay. So that's that's one part.
That is the essence of this particular case.
So, you see, after you have done away with the license, or rather, cancel the license, or fail to, decide not to renew the license.
Lordship.
What you have done is, in the meantime, you have issued the license to him.
Lordship. Okay. They have been issued a license as well.
But you have not arrayed them as.
We are not agreed by their action. We are agreed by the action of the government when they are not renewing our license. On the plea that matter is sub judice, so they will not renew. So, my lord, what I would pray, my lord, since we have raised the question of maintainability of the state revision, because injunction orders are appealable before the district judge. So, if the lordships hear us and come to a conclusion that the revision is maintainable, then the question of their impleading will come. If lordship comes to a conclusion that this revision is not maintainable, then there is no need to implement it. So, what I would pray, my lord, lordships may hear maybe next week or after 2 weeks, my lord, the injunction or the revision, the question of maintainability. If the lordships come to a conclusion that yes, revision is maintainable, then their application for implementation may be considered.
Maintainability, I'm ready once my lords can have it tomorrow as well. We don't need to wait for another 2 weeks because that will delay the hearing on maintainability as well as delay the application for impleadment. So on maintainability, if it's convenient to my lords, we can have it tomorrow or day after, any date.
Whoever is ready, you can accompany me to the airport, and from the airport to.
I wasn't aware lordship was not going to be here.
I'll be leaving for Bhopal tomorrow, so we might as well have it.
To lordship's convenience.
We'll have it online if there's connectivity in the flight. So we'll after a week.
After a week.
So in the meantime, you can respond
Yes.
To his application if so desired, and we'll see how things fit in.
In fact, my instruction is that the matter is now there is some talks are going on.
But the better you if you can settle the matter, good.
We have been trying to settle it.
Because so many people's dreams are depending on you.
2 civil divisions and suits matter can be resolved.
You can suggest a date.
23?
24, 25 minutes.
24, 25, we have those, that trust matter.
It's 22nd, 23rd months. We'll make an attempt.
29, 30.
Let's put it 29. I think hopefully by that time you
Lord.
getting a main matter as submitted by the parties. List this matter on 29 for hearing. Nanti kita main miss case ni. Heard Mr. Liman Nobri, Letter Counsel, appearing for the petitioner, public intervener, seeking indulgence of this court to intervene in this matter as a party respondent. Though the petitioner state has no objection to the petition, however, the respondent,
3 minutes.
Khasi, has submitted through its counsel through the learned senior counsel, Dr. N. Musica, that opportunity may be allowed to respond to the same. Accordingly, any response to this petition may be filed within the next date fixed. This is matter on 29.
Highly pledged.
Item number 2.
Your Lordship, the rejoinder has already been prepared and the same has been sent to the petitioner for signature. In the meantime, Your Lordship, the petitioner has been hospitalized, Your Lordship. So kindly grant us 2 weeks for filing our rejoinder affidavit, Your Lordship.
On pre-made by the petitioner, the rejoinder is allowed to be filed within the next date fixed. This is matter after 2 weeks.
Highly obliged, Your Lordship.
Item number 3.
Lordship, this is a matter where the petitioner has been booked under section 354 IPC. Now the...
Yes, who's appealing?
This is 482, yes. Yes.
What is this?
Senior counsel Mr. Mahanta is not here today. They had informed me.
No, matter is ready for hearing.
No, Lordship.
No, what is left? Any?
There was a limited query from this honorable court that whether section 354 IPC is gender neutral or
okay,
not. That is the limited issue. So since...
But in any case, if that is the case, we can hear the matter, you see, as a whole, and that issue will be decided.
I'm ready. But however, I was communicated this morning that Mr. Mahanta is not well.
He's on the
health
medical
issues
treatment at the moment.
So how long?
He's on the medical
I
treatment.
said, how long would you?
3 weeks time.
Prayer submission has been made by the learned counsel, informing this court that the learned senior counsel who is conducting this matter is personally indisposed on a ground of health issues. It is therefore prayed that this matter may be adjourned for the day. As prayed for, list this matter for 3 weeks.
Deeply obliged.
Item number 4.
Yes, where were we here?
Lordship, on the last occasion, Lordship had more or less made up Lordship's mind that this matter may have to be taken up by Honorable Guwahati High Court. This was based on the Northeast Areas Reorganization Act plus a judgment of the Division Bench of this Honorable Court. So what I could read of Lordship's mind was that Lordship was more or less convinced, but Lordship was kind enough to give me an opportunity to go through the judgment. I'll just take 5 minutes of Lordship's time in an attempt to unconvince or dislodge Lordship's conviction, if Lordship just allows me. Right at the beginning, my Lord, and possibly for the last time, I would request Lordship to look at the related provision, that is 28I(3), based on which respondents are contending that matter needs to be adjudicated by Guwahati High Court.
Yes, 28I(3).
I'll read, my Lord. Notwithstanding anything contained in subsections 1 and 2 or in sections 28A, but save as hereinafter provided. That is important, my Lord. There is a saving clause. Save as hereinafter provided. The Common High Court shall have, and the High Court of Meghalaya, the High Court of Manipur, and the High Court of Tripura shall not have jurisdiction to entertain, hear, or dispose of, number 1, appeals. Number 2, applications for leave to the Supreme Court. Number 3, applications for review. And number 4, other proceedings where any such proceedings seek any relief in respect of any order passed by the Common High Court before the commencement of the Northeast Areas So-and-so Act of 2012. So my first request to this Honorable Court is to kindly observe that the prohibition in respect of jurisdiction under clause 3 is in respect of 4 types of proceedings. One is appeals, not our case, my lord. Second is applications for leave to the Supreme Court, not our case, my lord. Third is application for review, again not our case, my lord. The fourth is other proceedings where any such proceeding seeks any relief in respect of any order passed by the Common High Court. So the only question that would arise is whether our petition for condonation plus restoring the matter would qualify as other proceeding, because it obviously cannot qualify as the first 3. My submission in that respect, respectful submission in that respect, is that these proceedings are qualified proceedings where such proceedings seek any relief in respect of any order passed. Now, I am not seeking, through this petition, I am not seeking any relief. Lordship will have to kindly appreciate relief in the sense it is used here or in any other statute would be to dislodge an order on the basis of incorrectness of the order. So, for example, my lord will allow me, if I am of the view that the order was passed wrongly, in that case I file an appeal or any other petition and I seek relief against that order. In this case, my lord, my writ petition was dismissed for default of the counsel, for non-appearance of the counsel. I cannot, in all honesty, find a fault with that. I cannot seek any relief against that. I cannot try and convince this honorable court that that order was wrong.
Yes.
Because that order, on the face of it, in these circumstances, it was passed.
The merit of the matter has not been decided as such.
Yes, my lord. So, as the limited focus of my petition is only that order of dismissing my petition for default. I am not seeking any relief against that petition, against that order. I am not trying to convince this honorable court that the order was wrong. In other words, my lord, in very simple terms, my petition I submit would not qualify as a proceeding seeking any relief against any order passed by Guwahati High Court, my lord.
So, Mr. General.
Yes, my lord.
I think you see, now we have to pinpoint on the word relief.
Yes, my lord. Yes, my lord.
What exactly is relief?
Yes, my lord.
Vis-a-vis the impugned order or the order of dismissal?
Yes, my lord.
Whether it fits in the frame of
yes, my lord.
As has been indicated herein.
Yes, my lord. Yes, my lord. My lord, I had attempted to do some homework on this exact question that has fallen from lordship, the meaning of the word relief. Unfortunately, my lord, there are judgments which have explained, which have set out what I have just submitted, that relief used in any statute would postulate or require a situation where the petitioner assails an order as being incorrect and therefore seeks relief against that order. But those judgments, my lord, are old English judgments.
That would be the general understanding.
Yes, my lord. Now, in this case, lordship will appreciate, I am not attempting even for a moment to say that that order was wrong. I am only maybe invoking equity by trying to convince.
Mr. General, let's ponder for a moment.
Yes, my lord.
See, the impugned order was passed.
Yes, my lord.
Wherein your application was dismissed for default or whatever.
Yes, my lord.
In that, you see, at that point of time, you've been non-suited.
True, my lord. True.
So now, to come back to the original, situation,
yes, my lord,
or position,
yes, my lord,
that would be, a relief sort.
Lordship, that would be one, I have to concede that would be one way to look at it. That would be one way to look at it, but possibly the answer to what Lordship has expressed is in subclause 4 of this section. If I'll read subclause 4, any order, and just to reiterate, my lord, subclause 3, what I had focused on was there is a saving provision in the second line,
yes.
Save as hereinafter provided. So there is an exclusion of jurisdiction in subclause 3, but save as hereinafter provided. Hereinafter in subclause 4, what is provided is any order made by Common High Court, clause A not relevant, any order made by the Common High Court, clause B, in any proceeding with respect to which the Common High Court retains jurisdiction by virtue of subsection 3 shall, for purposes, have effect not only as an order of the Common High Court, but also as an order made by the High Court of Meghalaya. So there is I would submit there is a deeming provision, irrespective of what is stated in para 3, in subclause 3, that any order made by the Guwahati High Court, in a case where Guwahati High Court possibly still has jurisdiction, would be an order that can be considered to be an order not just of the Guwahati High Court, but also an order of this Honorable Meghalaya High Court. So if that is the position, my lord, if this order in question, the dismissal order, is to be considered as an order passed by this Honorable High Court, records also being here, I would submit that this Honorable High Court would be in a position to dislodge the order. So
that is a foregone conclusion.
Yes, my lord. Yes, my lord. So irrespective of what is stated in para 3, subsection 3, para 3 itself contains a saving clause. It is made subject to the later provisions. Later provisions make it very clear that the impugned order in question in this case, is an order of this Honorable High Court. If it is an order of this Honorable High Court, I submit, is very well entitled to dislodge or adjudicate upon that particular order, my lord. That is my second submission. My last submission, in an attempt to convince this Honorable Court, is based on the judgment that was submitted, the division bench judgment, if Lordship kindly recalls. That was a judgment passed in 2018. Now, before going to that judgment, I will humbly draw Lordship's attention to what the Supreme Court has stipulated, or what guideline has the Supreme Court laid down as to how a judgment is to be read, my lord. I am covering ground which has already been covered many times before by Lord. But Lordship will kindly indulge me. 2006 judgment, my lord, para 12 of this judgment. I am only relying on one line from para 12. I'll read the entire para. Para 12. It is in that context, the court clearly came to the opinion that the provisions of subsection 1 of section 50 were not required to be complied with. The said conclusion was arrived at inter alia upon noticing the provisions of subsection 4 of section 50 of the Act. It was therefore not necessary for the bench, with utmost respect, to make any other observation. It was not warranted in the facts of the said case. A decision, it is well settled, is an authority for what it decides and not what can be logically deduced therefrom. So very well known position of law, that any decision, any judgment being relied upon is an authority only for what it decides, not what can be deduced or assumed from that judgment. Now, in this background, with keeping this stipulation or guideline of the Supreme Court in mind, Lordship may kindly, for a moment, revisit this judgment of the division bench, my lord. So this judgment of the division bench, the question would be, what is it an authority for? It is an authority for something that is very different, my lord. Something that is very different from the circumstances of our case, my lord. I'll draw Lordship's attention to page 5. Prior to that, my lord, page 3. Page 3 of this judgment. Just one line is of interest and relevance before we go to page 5. Below the quoted portion, my lord, below this section 28 which has been quoted, just one line from there. A perusal of the aforesaid provision clearly indicates that after the commencement of the Act of 2012, the Common High Court, namely Guwahati High Court, will have no jurisdiction in respect of matters where cause of action arises in the state of Meghalaya, Manipur or Tripura. So, express observation in the same judgment from the same bench, my lord, that after 2012, where cause of action arises in Meghalaya, Guwahati High Court will not have jurisdiction, my lord. Number one. Number two, I would say more importantly, is at page 5, my lord. Page 5, they have referred to a Supreme Court judgment on another issue, whether it is mandatory or discretionary, this provision. After that extracted portion, my lord, having heard the learned senior counsel on this aspect, we are of the view that the submissions made by the counsel cannot be accepted. The decisions cited are clearly distinguishable and are not applicable. In the first instance, the court finds that the provisions of Section 28I(3) confines the territorial jurisdiction for filing an intra-court appeal or an application for leave to the Supreme Court or an application for review before the Common High Court only. Full stop. Subsection 3 of Section 28I makes it apparently clear that the provision is mandatory, giving no choice to the litigant to choose between the two forums. Lordship, I'll pause here. So again, the question which came out from that Supreme Court judgment, what is this judgment of the Honorable Division Bench an authority for? It is an authority to the effect which states that any intra-court appeal, any petition for review, or any petition for leave to appeal to the Supreme Court is to be taken up by the Common High Court. It does not speak of that fourth category, proceedings. So I would humbly submit that the reliance being placed by the respondent on this judgment
is there a deliberate exclusion?
Deliberate
under the facts and circumstances of this case.
Lordship, conscious or unconscious, we can only assume, and Supreme Court is clear we should not assume. What is there is there. What is there in black and white, it is an authority only to that extent. So this judgment of the division bench is an authority which says appeals. This was an appeal, intra-court appeal. Appeals should be taken up by the Common High Court. We bow down to that. We have no dispute with that. But ours is not an appeal, my lord. It is certainly not a petition for appeal to the Supreme Court. It is not a review petition also, my lord. So this judgment, very respectfully, would not answer the question one way or the other, my lord. Now, to sum up, my lord, at the end of the day, the position is that at one point he had approached the petitioner had approached the Honorable Guwahati High Court. This was in 2012 itself. At that time, he was given a legal aid counsel by Guwahati High Court in Guwahati. That legal aid counsel opined he should go to Meghalaya High Court. Based on that, after many years of things which I had described on the last occasion, after many events had occurred, finally he again approached the Guwahati High Court. Guwahati High Court again referred the matter to their legal services authority. Their legal services authority transferred the matter here. So he has been, if I can use the expression, being kicked from pillar to post. He is a layman. He follows whatever the authority tells him to do. At one point, he was told by his appointed legal aid, or the appointed legal aid counsel opined that Meghalaya High Court has jurisdiction. Finally, matter reached Meghalaya. Now he's being. There is an attempt on the part of the respondent to again say that no, he has to go back to Guwahati. Lordship, this matter has been going on for 13 years. Some fault is there with him also. I have to concede to that respect. But at the end of the day, my lord, may kindly take a pragmatic view of the matter. Under the provision of the Act itself, subclause 3b, the proviso, subclause 3 proviso, if lordship sees, once the matter is taken up by Guwahati High Court, the Chief Justice of that High Court, means Guwahati High Court, if he is of the opinion that the proceedings ought to be transferred to the High Court of Meghalaya, the proceedings will be transferred. So even if lordship does not agree with me today and agrees with the respondent and transfers the matter to Guwahati High Court, at some point, invariably, and I can say this with all confidence at my disposal, Honorable Guwahati High Court's Chief Justice will transfer the matter back to this Honorable Court, and we'll be back where we are today, my lord. So my request was for this Honorable Court to kindly take a pragmatic and a realistic view of the matter, that if the matter is ultimately again, and under no circumstances will Guwahati High Court adjudicate this matter, because the cause of action is in Meghalaya. They will send it back at some point, even if it is transferred there. If it is to come back at some point today, 1 month later, 1 year later, 2 years later, to this Honorable High Court, why not now itself, my lord? Why not now itself? So I know that I am more than statute, I'm invoking equity or the sense of kindness of this Honorable Court. But the circumstances are such, my lord. This particular petitioner has suffered at the hands of various people, various authorities over time. Lord, you may kindly grant him some kindness after 13 years, my lord. That's all.
My lord, I have to respond to what my friend is submitting. first, my lord, if Lordship kindly has a look at the application, my lord, that has been filed. One is condonation application, my lord, and the other one is restoration.
Yes.
Page 10, my lord.
Page?
Page 10 of the application.
Page 10.
Prayer portion, my lord.
Yeah.
And after the hearing be further pleased to pass necessary orders vacating order dated 30/10/2009 passed in WPC number so and so and consequently restoring WPC number so and so.
Just one.
So my lord,
Just one.
but there are two applications of record, my lord. One is for condonation of delay.
Yes.
The other one is for restoration, my lord. My lord, the restoration application has not been registered, but it is on record, my lord, as temporary file, my lord. No?
Yes.
So, my lord, there is a specific relief sought against an order passed by the Guwahati High Court, my lord. They are asking for vacating the order passed by the Common High Court, my lord. So, in my humble submission, they will squarely fall under the phrase, my lord, any other proceedings. That's the first submission, my lord. Lordship will also kindly appreciate that it is not that all cases pertaining to Meghalaya were required to be transferred by the Guwahati High Court, my lord. A discretion was given to the Chief Justice of the Common High Court, my lord. May I refer to that portion, my lord, in the Act, my lord. Para 3 proviso, my lord.
Yes.
Para 2, my subsection 2, my lord, in fact. So, my lord, it says, my lord, the matter, such proceedings pending in the Common High Court immediately before the commencement of the Act, as are certified, whether before or after that day, by the Chief Justice of that High Court, having regard to the place of accrual of the cause of action and other circumstances to be proceedings, which ought to be heard and decided by the High Court of Meghalaya or the High Court of Manipur or High Court of Tripura, as the case may be, shall, as soon as may be after certification, be transferred to the High Court of Meghalaya or the High Court of. So the Chief Justice of the Common High Court was given this power to transfer the case, my lord. Now the Chief Justice of the Common High Court has to determine on the basis of place of accrual of cause of action, my lord. So, my lord, then the third part of this entire scheme is, my lord, that
yes,
the meaning of expression transfer, my lord. As I submitted on the last date also, even maybe the records are transferred, but the transfer of records of a disposed case, my lord, in the strict sense is not a transfer of case, my lord. It is simply a transfer of records. The reference, my friend was referring to subsection 4, my lord. It says, my lord, any order made by the Common High Court before the commencement of the so and so in any proceedings transferred to the High Court of Meghalaya. So transferred here, my lord, in my humble submission, you only refer to a subsisting case that has been, a pending case that has been transferred to this Honorable Court. My Lord, what is the reason or what is the object of inserting this clause? For example, a writ petition was filed in Guwahati High Court, my Lord, before separation, and certain interim orders has been passed in that. And subsequently, the cases have been transferred to Meghalaya High Court. To cover that aspect, that the interim order passed by the Guwahati High Court will be in force, and but those orders will be in force only in a pending case when the case has been transferred to this Honorable Court, my Lord. Any order that was already passed by the Honorable Guwahati High Court disposed of matter, only simply case records have been transferred, my Lord. In my humble submission, that is to entertain this application, my Lord, for restoration or for continuation is beyond the scope of Section 28, my Lord. That is not the legislative intent. I have full sympathy for the petitioner, my Lord, but he has to follow the law, my Lord. In my humble submission, this Honorable Court will not have jurisdiction to recall the order passed by Guwahati High Court, my Lord. What my friend was trying to read, my Lord, that other proceedings are not mentioned in the judgment, my Lord, because that was not an issue directly in that case.
Exactly.
But when appeal, because that subsection includes four things, my Lord: appeal, review, SLP, and
other proceedings.
Any other proceedings, my Lord. So that was not an intentional omission, or that's not even an obituary in that case.
See, whatever the case may be, if it is intentional or not intentional, the fact remains that as Mr. Jindal has cited the Supreme Court judgment, we have to look at the letter of the
statute is very clear.
Not necessarily the statute, but the letter of the order pass. Of course, vis-a-vis the statute, that of course that has been.
Because that case pertained to appeal, my Lord, so the emphasis was on the appeal part, my Lord.
Appeal part.
But it does not mean that when subsection mentions about four things, my Lord, it does not necessarily follow that has been intentionally excluded.
But we cannot impute meaning where there is none.
When it is not clear, when that was not even an issue in that. Other proceedings was not a subject matter in that.
So in that sense, that judgment may not be relevant here.
That is not an authority on other proceedings, my Lord. That is an authority on.
Exactly.
But in my humble submission, there are four circumstances mentioned in subsection 3, my Lord. So statute will cover all four circumstances, my Lord.
So, Mr. Jindal,
Yes, ma'am.
As queried by this court, if you can at least shed some light or refer to some authority only on the concept or the word relief as
Very well.
in the context of this case.
There are English judgments, quite old judgments. I'll try and get hold
as long
of
as the concept is clear.
Yes, ma'am.
It was made clear.
Understood.
There's another difficulty if your Lordship passes an order. When the case records were transferred from Guwahati High Court, some data must have been maintained, my Lord. How many disposed of cases transferred and how many?
In fact, just to clarify on this point, we checked up with the registry. Records have always been here. They were never transferred from Guwahati.
See, I think that is I think that's common sense.
Yes.
No, records in the sense, my Lord, when the cases were transferred from Guwahati High Court.
Okay.
Maybe records are lying sealed because it was a long bench.
Yeah, but the data.
Some data must be maintained.
The data, yes.
That how many disposed of cases have been transferred to Meghalaya High Court, and how many case records, how many pending cases have been transferred, and how many disposed of cases. Records of disposed.
How do we do that? We have to.
That's the reason, my Lord, why intentionally this.
We have to request the registry then. We have to request the registry to supply the data.
Ma'am, submission, rather than going into legal complication, my Lord, they can withdraw this or this matter can be closed by giving the liberty to file a fresh application in Guwahati High Court. Now legal aid, Mr. Jindal is there, he can coordinate with any legal aid council in Guwahati.
My ambit.
If the Honorable Chief Justice of the Guwahati High Court transfers it, my Lord, that is the correct procedure.
Lordship has
But
given
we cannot bypass that on the ground of.
Lordship has given me an opportunity to satisfy Lordship on that relief part. I am grateful for that. Lordship may kindly give me a few days time, about a week's time, I'll come back. If Lordship is satisfied at that point, well and good. If not,
Yes.
the course is quite clear, my Lord.
It's it's quite interesting.
It is.
The interplay of of provisions.
Yes, ma'am. Yes.
And the meaning attached to this.
Yes,
same. Well, as we all know, you see, there could be two views to a matter.
Yes.
Two views to an interpretation of a statute.
Actually.
So it's either
there must be many other cases, my lord, where restoration application were filed in court. But now to locate those orders, my lord, I can make an effort to locate those orders also.
It is also, you see, incumbent upon you to assist the court in this respect.
My lord, because those orders will not be reported, my lord.
Yes, it may not be
reported. This is a speaking order, so this is reported, so I could locate it and I could place it, my lord. But those 4 lines order or maybe withdrawn with the liberty to file.
What you can do is you could okay, off the record. You can also request the registry look into it. I mean the Guwahati High Court registry look into it.
The difficulty though that time it was not digitized, my lord. 13, 14 orders are not all orders are not available online.
That's interesting.
After 16, most of the orders are there on the website.
Yeah, there may have been, like you say, but not that it has not any matter pertaining to Meghalaya High Court. I don't think it.
There restoration. There must be some cases when the cases were dismissed for default by Guwahati High Court. Or maybe there will be converse cases that restoration itself was filed in Guwahati High Court.
And even if it is filed in Guwahati High Court and subsequently transferred here, there would be some indication. You see. There would be some.
The difficulty is not digitized. To check each and every case in record room will be difficult process.
That is also true.
But in my humble opinion,
so we'll leave it at that. We'll leave it at that, and perhaps next time around, Mr. Nidal can cite those any
yes, ma'am.
authority.
Yes, ma'am.
And if you can try to find out through your own sources or resources if there are some precedents, some cases which have.
But even then, my lord, whether that can be treated as a transfer of the case, my lord, can it be taken that the case has been transferred and lordship can pass an order in that?
While expressing sympathy with the petitioner, my learned senior is fighting tooth and nail on every step.
No, but then we have to look at the legality of it.
My only endeavor is to assist the court in passing the correct order.
Naturally, that is everyone's endeavor.
There is nothing. I have no grievance. Ultimately, I know that this case will come back to Shillong itself.
Therefore, that is the underlining.
Yes, so therefore, my submission was for this honourable court to take a pragmatic view. Anyway, Lordship, I'm obliged that Lordship is giving me some time, about a week's time.
We have to be careful here because you have to be.
Inter-High Court matter.
It's inter-High Court. Inter-High Court. The issue of judicial propriety will come, judicial discipline, and so on and so forth.
Naturally, we are well aware of that. Obliged.
Heard learned counsel of the parties as the matter is part heard. List is after 1 week.
1 week.
This is matter to 1 week.
Obliged. Highly obliged.
Item number 5.
May it please your Lordship. Lordship, in this case, the original petitioner was substituted by her son. This is a matter where, in lieu of compassionate appointment, ex gratia payment is given to the dependents of the deceased. So in this case, the son has been substituted, and your Lordship had observed that perhaps if the respondents wish, we can file an affidavit to that, because the cause title has also been changed in the meantime. My humble prayer is that, Your Honor, I had filed an application, an affidavit, objecting to the substitution of the son as a petitioner. So this affidavit, I may be allowed to rely on this affidavit at the time of hearing. 3rd day of May 22nd, 2022, Your Honor, Your Lordship.
So, see, the issue here is with regard to the some pensionary benefits.
Not pensionary, ex gratia. The employee of Vijaya Bank, which is now Bank of Baroda, had died in harness, Your Lordship, in the year 2001. And on his death, Your Lordship, the son had applied for compassionate appointment. Now, because the scheme of the bank had changed, they said that there is no scheme for giving compassionate appointment, but ex gratia payment to the dependent of the deceased. Now, Your Lordship, then the deceased had filed an application for ex gratia payment. The deceased original petitioner, Your Lordship, the mother of the present petitioner. She had then, in the meantime, while the case was pending, she expired.
But she was not entitled to because she has some other
source of income was more than 60% more than the last drawn basic salary of the deceased.
That
So
is
she was
that
not
we are
entitled.
disputing.
So the thrust of the petitioner's contention is that the two should be divorced. You cannot club the two together. That's your contention.
We are saying that
the source of income.
The two
We're talking about
because the deceased was enjoying two pensions, Your Lordship. The deceased employee, he was enjoying, so taking all that income into consideration. Then the original petitioner was drawing her source of income, monthly income was more than 60% of the last drawn, and so she was not entitled, and we rejected the application.
So that we are disputing before Your Lordship.
Okay. Have you referred to any specific rules in that regard?
Yes, Your Lordship. They have a scheme. That is annexed, Your Lordship.
Not with regard to the quantum, but with regard to the eligibility as to receiving two incomes from two
Yes, Your
sources or
Lordship.
otherwise.
I have got a citation for that also, Your Lordship. Where even the interest from any fixed deposits are also calculated while calculating the monthly income.
So now the legal heir or the legal representative now has come in the picture. He is the son of the.
He is the son of the deceased
petitioner.
Yes.
And is he in receipt of the family pension and so on and so forth?
He wouldn't be because he is already employed, Your Lordship.
He's
So he's not even the dependent.
Then how would he?
How is he
how would he
entitled?
qualify?
If I can argue my case, my lord, when the time comes.
Yes, yes.
I mean, I would submit, my lord, in my respectful submission. The respondent's case is what my friend is saying. But I will place my case, my lord. But today, what happens, my friend submitted that she is not filing the affidavit. She will rely on that. I have no problem with it. Since they have already filed an affidavit,
to allow me to rely on this affidavit, which is dated 23rd May 2022.
So if it's on record, it's on record.
It's already on record, Your Lordship. So that is my prayer for today, and if the matter can be heard, my friend has got some inconvenience, so we'll.
Well, I request that the matter be taken up in the month of June, any day, first week, second week, whatever, convenient.
So we'll adjourn it for 3 weeks.
Sorry, madam?
3 weeks.
3 weeks will do, no? From today? Today is what date?
Today is the 11th.
11th. So it'll be in the first week of June, I think.
Yes.
Yes.
After 3 weeks.
After
We'll
3
take it up
weeks.
first week of June.
First week. Week beginning 5th, maybe. 5th of June, madam.
5th of June.
Week beginning 5th of June.
Then maybe that'll be 4 weeks from now.
Well, all right.
As prayed for by the learned counsel for the petitioner. Not objected to by the respondent. List this matter up to 4 weeks.
All right.
Pleasure.
Item number 13.
I'm waiting for respondent number 12.
Where's Mr. Debnath?
This is maybe in code number 2.
End of the board.
Item number 15.
For responding 1, 2, and 3. Item allowed was more or less heard. Even my the learned counsel for the private respondents have filed the written argument, as well as some additional affidavits were filed somewhere towards December, January, my lord, of this previous year. So we have communicated, my lord, and in person to our communication to the district council, my lord, they have given us some records, because essentially the dispute is a knockmanship dispute. So the genealogical tree, as well as the orders which were passed right from 1975 onwards, some Mozilla reports and all have been given. So, my lord, we require some time to either place them or to, my lord, appraise this court about those records, because here, my lord,
You're appearing for the district council
because the written argument has already been filed by the private respondent.
and the petitioner.
No, I have not.
So in
No,
their
I will not file my note. I will do verbally.
So in their written argument, they have, my lord, indicated various Mozilla reports which date back to 1975 onwards, saying that, my lord, that they are the descendants of the last recorded.
Whatever the case is, that noted in your affidavit,
Yes, in our affidavit.
because you cannot go beyond the pleadings.
In the pleading we have mentioned also. Yes, but the documents are not there. So we have got those documents from the district council. So we just want to go through it.
The problem is actually on the last question there was an order. The problem is the petitioner have not enclosed certain orders.
Yeah, so those also have been filed by way of an additional affidavit.
At the time of hearing, when the court has queried those orders, he has filed some order which has not been enclosed earlier. So
No,
that is the only thing. But
No,
my learned friend is submitted that also is right, because he has stated many things in his petition, but that those order which he has reflected in the order, that petitioner has not enclosed it. But however, in our affidavit, whatever document that we are relying, we have enclosed it.
Now,
But the petitioner has not enclosed. But now at the time of hearing, twice he has filed some additional affidavit to bring on record some documents. But however, there is one order that even petitioner has failed to file some additional affidavit.
Thereafter,
yes,
that order was there. Thereafter, they have filed it.
Yes.
So what I am submitting is all these affidavits and the new orders which have been brought on record. We had communicated, and they have replied along with their original record. So we want to go through the entire history and, my lord,
You want to respond to the affidavit in
that.
In other words,
no, we don't want to respond to it. We just want to ascertain, my lord, because they have brought in the records.
only their intention is that to bring the record, relevant record, produced before the court and the hearing.
because whatever you have,
I have already
brought
filed.
is already-
I have already filed because some order was missing. Subsequently, I am able to collect it and submit it. That is, we rely on no more document with us.
So I'm just praying for 2 weeks time, my lord, so that we can just cross check with the records we have received and the hearing maybe.
At the meantime, Lordship, I have some document. It's not document, but it's a judgment. It is from this record only. I also maybe just file it in a proper way, but I can supply the copy. But it is good to just file in the additional affidavit. Otherwise, it is same thing from the record, but some record might have missed it, because it is going by his petition only. I come to find out those documents. So those documents means that orders I also have collected. So if Lordship permit me, just file it in the additional affidavit. At the meantime,
if it is a judgment, then you cite it in your.
These are the judgments
This is
passed
not
by
the
the
judgment.
courts of the district council.
Yes, it's not the Supreme Court judgment. It's a judgment from the lower court only. Since he has made an amendment in his petition, after going through those documents,
If that is the case,
record will come.
Mr. Dev will produce the record.
Lordship, yes.
Then you can point out. You see,
Yes,
But the
whatever.
from the
direction
record.
has not been given yet, my lord, to produce the record. So we have just communicated
Yes,
all
Lordship,
this.
then,
Now, so you are praying for producing the record.
So you want this court to to direct you to produce the record?
No, my lord.
Would that be convenient for you?
That is not required, in fact, my lord, because here the whatever is part of the records have already been brought in by either of the parties. We just want to verify those from our original records, because, my lord, now again.
But again, you see, Mr. Dev, if that is the case, then if we have to compare it with the original,
No, that is
whatever
for
whatever
our-
materials or whatever copies they have filed
Yes.
would relate to the records.
Yes, absolutely, my lord.
So
we just want
in
to
that
check,
case,
because certain, my lord, as the lordship sees, initially the petition was cast in a very, my lord, manner where all the
No,
documents were not there.
Petitioner is
Eventually, my lord,
on the fact some
eventually-
document was
Yes,
missing.
eventually, all those documents have come, and these documents have only come
During
from
the course of the
December-
hearing.
Yes, December of last year onwards, my lord. So we have communicated all that. We have received some comments and some documents. So you want to go through it, and the hearing may be taken up after a week.
Yeah, I
2
think
weeks.
then it will be better for you to produce the records.
And then we have to, my lord, communicate it again, take time. We don't have any objection, but
No, the order will pass. So within the next date fix, that can be done.
yes.
In the meantime, that will make it easier for you to.
Yes, my lord, because time and again either parties are filing.
Yes.
Yes. If Lordship permit, we may be allowed
Then
to
wh-
just inspect those
You
documents.
see, when the records come, you can inspect this.
Lordship,
Yeah.
yes.
Records are all.
Yes,
Nowadays, everything is public.
Some
You
more
know,
time.
so 2 weeks or 3 weeks.
3 weeks, my lord, in that case.
1 week time may be given.
1 week time.
No, because we have to communicate, they have to send it as a physical transaction, my lord.
But they have to classify it and all those
Yes,
things.
yes.
Yeah.
Actually, this is actually everything is done because it's.
You are the one who insisted for the records to be produced. Now we are saying.
I was not
Otherwise-
insisting. I was
No,
only
Mr.
saying to-
Sangma was the one who was.
I am also not insisting for the record.
Yes, in fact, it's not required. It's just because many additional affidavits have been filed by either of the parties, there has been a, my lord,
So you decide whether records are to be called for or not, or whether we.
It can be produced, but I should not give so much time because we are not able to do with anything because we are the NOCMA. Now, because of this case, we cannot do any function.
2 weeks time then.
it will, my lord, to produce the records, it will require some time.
Because already record is already here.
So, which is why I was submitting, my lord, that we will not produce the records because everything,
Fine.
majority of the.
Fine. If you
yes.
see, that's fine by the
So we
court.
I am just praying for an adjournment to go for about 2 weeks time, my lord, so that it may not be recorded the reasons and all.
Fine. On Mr. SDEP, Direct Counsel for the Respondent 1, 2, and 3, oblique GHADC, has submitted that some time is required for confirmation of certain facts and issues raised by the petitioner as well as the private respondent herein, and for the same to be verified and affirmed, so as to apprise this court of the factual situation of the list between the parties. On submission made, the same is allowed. As prayed for, list is matter up to 2 weeks. But please be sure, on the next date we'll because now everything is complete.
Yes.
Please.
Item number 16.
Item 16, my lord, was the matter which is already heard. Just regarding the school, my lord, where the NGO had allegedly snatched the merit list.
Yeah, I
So
think
now only the
state is to
has
file your.
Oh, my lord, my humble apologies. I could not do it.
In fact, if I may submit, my lord, and what my learned senior may also concur, the dispute is essentially between the managing committee.
Yeah, but as remarked earlier, the approval was given by the state.
No, because essentially what happens is the managing committee is the responsibility is on the managing committee.
Whatever has been recommended by
Yes, they
managing
will do
committee.
it. They don't cross-verify your. They get the letter, they approve it, as long as it's prima facie, my lord.
Only thing which is
And
stated in our affidavit.
those are there in the affidavit. So
Only thing which is stated in our affidavit is that we received, as far as the application for appointment approval, we received only with regard to the private respondents.
But there was now I've forgotten. There was some query made by the court,
No,
which
that
is
is the
pertinent to the stand of the state, or rather, which has to be clarified by the state.
My lord,
As to
completely skip my attention. My lord, if a week's time is given, my lord, whatever.
please look, because I think there must be something It's not a straightforward matter,
No, my lord,
because
in an affidavit, one thing we have stated that there was some meeting held, and there were the headman had recommended the name of the my lord petitioner.
on the recommendation of the headman, you have issued the.
No, we have not, because that cannot be done unless we receive a letter from the
Managing committee
that so and so person has been appointed. Kindly grant approval. Unless that letter reaches us, we cannot take any steps.
Yes, so now the managing committee has recommended the name of the petitioner.
No, well, the respondent, private respondent.
If I may,
Private respondent.
there was a selection process. The petitioner was selected as number 1, my lord. A merit list was issued, and pursuant to that merit list, a recommendation was issued by the managing committee as well as by the Gaubura, because the Gaubura was also part of the committee which has conducted the selection, my lord. Now it is the stand of the government that the recommendation by the school managing committee was not received by them, but the Gaubura recommendation was subsequently received. In the meanwhile, it is the stand of the managing committee, my lord, that the initial interview by which the petitioner was selected and recommended was, my lord, some NGOs had vitiated that, so to say, which is why they had issued a fresh advertisement, and pursuant to that fresh advertisement, the private respondent was recommended and subsequently approved by the state. So that is the case, my lord. Now my case is that yes, that one, there is nothing to indicate that this NGO allegation, entire allegation is true or not. There is no FIR, no complaint, nothing like that. And secondly, even so, once I have been given that selected in the merit list, I have a right to be considered. If they want to have a re-selection process or whatever it is, my lord, I should have been heard. And in fact, that earlier selection process was never, my lord, cancelled, saying that it has been vitiated because of these reasons. That's why we have to cancel the process and issue a fresh. So in my submission, it was the same process. It was never cancelled. So whatever it may be, my lord, the written argument has been filed by both the petitioners as well as the private respondents. It is only for the state to clarify as to the approval and the if they can verify as to the veracity of the allegation, whether the NGOs were involved and all that. Well, that is up to them.
So you look into this. You look into
officially there is no communication to the.
You look into this come up, with your reply.
Officially, there was no complaint filed to the state that this has happened, which is why we want to.
No,
nothing.
We have not received anything.
Which is why I submitted. This is just an afterthought.
The court will also have to look into the conduct of the state as to how, in what manner, because you are, I believe, the state is in the know as to what transpired during the first selection.
What usually happens is that when the posts are vacant, when appointments are being done, that state is not aware. It is only the managing.
Excuse me.
When they have initiated the steps for appointment or not, that we come to know only when we receive a letter from the managing committee that such and such post has fallen vacant, post was advertised, it was filled up, this is a recommendation, so that is when we
excuse me. So 1 week then, on the prayer of the energy appearing for the state respondent, seeking some more time in this matter, the same is allowed. This matter to 1 week.
Item number 18.
May it please your Lordship. Lordship, here the petition has been filed by the petitioner being aggrieved by the order dated 19/2018, where your Lordship, the learned district magistrate, had set aside
the order of the ADM, Additional Deputy Magistrate, the District Magistrate.
Oh, that issue of
That is the issue here, Your Lordship. So for that only the petition has been filed, stating that the District Magistrate has no power.
the order was passed under the rules, administration of justice rules.
It was not administration of justice rule, but it will come under administration of justice rule only, Your Lordship. But here they have not stated anything. Only the, Your Lordship, I would like to bring to the page number 14 of the petition, Your Lordship. Page 14, Annexure A4. I may be allowed to read, Your Lordship.
Yes.
Seen the petition filed by the counsel of Sri Dilip Kumar Chaudhary dated 9/10/2018 appealing against the impugned order passed by the learned ADM Bagmara dated 4/10/2018 which reviewed his own order dated 28/9/2018. The impugned order of the learned ADM Judicial ordered the execution of the order dated 28/9/2018 releasing the vehicle BR number so and so, its owner Sri Dilip Kumar Chaudhary, the duly registered owner of the vehicle. The criminal revision filed by the petitioner is allowed. Registered the criminal revision. Heard the counsel for the petitioner who argued that the order passed by the learned ADM Bagmara order dated 4/10/2018 in GR case number 70/2015 is in breach of section 362 CRPC, which disallowed the court to review its own order. Heard also the learned PP who does not have any objection. The petition is allowed. The order dated 4/10/2018 passed by the learned ADM Bagmara is set aside. Let the vehicle be released immediately after the execution of proper Jimmanama by the registered owner of the vehicle. Send copy of this order to SP South Garo Hills and OC Nangal Bibra PS for necessary compliance. Case disposed of. So, we being aggrieved here by the order of this, Your Lordship, we approach here before this Honorable Court, stating that the district magistrate has no power to entertain any appeal or revision petition passed by the ADM, because additional district magistrate and district magistrate on par, Your Lordship. They have equal power, Your Lordship. And for that, the additional district magistrate or additional deputy commissioner is being appointed in Meghalaya, Your Lordship, under the...
That is why I see
Your Lordship.
the query of this court is under what provision of law or rules this order was passed.
Your Lordship. Here
perhaps,
they have...
Perhaps it was passed under the Administration of Justice Rules 1937.
Naturally, Your Lordship, because they will be empowered under that only, Your Lordship.
Because at that point of time, separation has not yet. But this is in 2018.
2018,
when
Your
did
Lordship.
separation took place?
Yes, Your Lordship. And
2020, I'm not mistaken.
Yes, Your Lordship. And here, Your Lordship, I would like to beg to submit, Your Lordship, that the appointment of additional deputy commissioner or additional district magistrate is by the state government comes under the Assam Autonomous District Administration of Justice Act 1960, Your Lordship. 1960. I have the copy of the synopsis also, Your Lordship. I have mentioned in page number 7, Your Lordship.
If I please, Lordship, the separation was carried out by notification dated 14 December 2020, Lordship.
Yeah, that's what I
just want to clarify.
So as on 2018, it is not yet.
No, it was not separated, Your Lordship.
So, what is the stage of the main case now?
Lordship, the CD was called for. Lordship, the FR was filed by the IO concerned, but then the petitioner in this case had filed another case before the Chief Judicial Magistrate, South Garo Hills, for further investigation.
Yes, so that show cause was filed.
Lordship,
And what is the order passed thereafter?
Lordship, as per the CD, this is, may I read out, Lordship? In the order dated 6/3/23. Now I open the case. Now I open a case diary at PI Court, Bagmara, on the strength of the above noted case. Now receive court order passed by Shri D.S. Marbanyang, Chief Judicial Magistrate, South Garo Hills, in connection with Nongal Bibra, PS case number 16/8/2015 under section so-and-so, dated 30th/11/23. For causing further investigation since complainant Sri Rakesh G. Momin was objected the submissions of FR in the court. Hence, the case is under investigation. Now I close the case diary at PM Pamara.
Yes, Mr. Chaudhary. So we'll hear the
Lordship would excuse me, I'm appearing through video conferencing today.
If you are audible.
Lordship, I'll just go briefly through the facts once, though my learned friend has already stated it.
Just a moment. If you are ready, we'll take up the hearing in earnest.
Now, I'm ready, Your Lordship, I'm ready.
Please start, Mr.
Yes, Your Lordship. Your Lordship, the gist of the case is that the petitioner was carrying out the business of coal and owned several vehicles for that purpose. But due to imposition of ban on coal mining by the National Green Tribunal, the coal business of the petitioner came to a standstill and was compelled to station parked all vehicles owned by him at the petrol pump, namely Genesis Service Station, situated at Jadi Jitian, South Garo Hills, Meghalaya. On 9/8/2015, I have mentioned in my synopsis, Your Lordship. On 9/8/2015, the respondent number 2, Sri Dilip Kumar Chaudhary, and 1 Sri Brinerji B. Sangma, along with their goons, came to the aforementioned petrol pump and assaulted the staffs of the petitioner and forcefully took away 4 motor vehicles, truck, Your Lordship, bearing registration number AS18A 4094, AS18A.
You are reading from?
Page number 2 of my synopsis, Your Lordship.
Why read synopsis?
Because synopsis, it will be everything I have compiled, Your Lordship, and it will be easy to understand.
Yes, please go.
Yes, Your Lordship. AS18A 4094, AS18A 1771, AS18C 0637, and AS25B 7432. As such, the humble petitioner filed an FIR dated 10/8/2015 before the officer in charge of Nangal Bibra Police Station, South Garo Hills, Meghalaya, against the respondent number 2, Sri Dilip Kumar Chaudhary, and 1 Sri Brinerji B. Sangma, and others. And the same was registered as Nangal Bibra case number 16/8/2015 under section 406, 402, 384, 323, 34 IPC. Copy of the FIR has been enclosed with the petition, Your Lordship, and marked as Annexure A1, Your Lordship, which is in page number 9 of the petition. Annexure 1, page number 9 of the petition, Your Lordship.
Just read out the FIR.
With reference to the subject noted above, I beg to state that 1 Sri Banerjee B. Sangma, proprietor of petrol pump situated at Jadi Jitian, asked for advance of rupees 50 lakhs as advance against petrol pump Genesis service station, so that he will buy BMW, Mercedes and good Apple computer, and for purchase of land. I had refused to give him, as Sri Banerjee B. Sangma, while his acknowledgement of debt letter dated 10/11/2008 had already accepted that the earlier amount of rupees 86 lakhs 560 which I have given to him will be returned by him before 31st/3/2015. This amount was paid by me on the basis of the agreement dated 27/2/2004 and power of the attorney dated 27 February 2004. The next para, Your Lordship. However, when I refused to pay the illegal demand of rupees 50 lakhs, Sri Banerjee B. Sangma told me that he will sell the pump to other person and teach me a lesson. After 4 weeks, he and his goons went to Jadi Jitian petrol pump, Genesis service station, and assaulted my staff, Mr. Manoranjan Deka. Thereafter, they told my staff that they will take my trucks and sell them in Assam. Further, they also told my staff that they will use the truck for illegal drug supply, and if police catches the truck, the owner, that is me, Rakesh Momin, will go to jail. Sri Banerjee B. Sangma and his goons, namely Dilip, Sudho, Binod, Samsul, Mohiruddin, Pranav and Chand Prakash, have forcefully took my Ford truck on 9/8/2015, which was parked in petrol pump Genesis service station. The number of trucks are AS 18A. All the numbers, your Lordship, just now I have read out. And further said, I know the address of Chand Prakash, who is son of Bed Nath of Jogi Gopa, Bogai Gaon, Assam. I am enclosing the Xerox copy of RC and also the insurance paper of the trucks and acknowledgement receipts 10/11/2008. Please take immediate action. This is the FIR, Lordship, which was filed on 10 August 2015 and against the total 8 number of the accused persons I have named in the FIR, which was registered on the same day under section 406, 420, 384, 323, 34 IPC as Nangal Bibra PS case number 16 within bracket 8 of 2015, Your Lordship. And here only the one truck was recovered from Jogi Gopa and brought to the Nangal Bibra police station. And there, Your Lordship, they filed the JIMA applications before the ADM, Additional District Magistrate, Baghmara, for the release of the vehicle. The vehicle was released wide order dated on JIMA, Your Lordship, on wide order dated 28/9/2018. Later I came to know that the vehicle has been released on JIMA, order has been passed by the Additional District Magistrate, wide order dated 28/9/2018, Your Lordship. I came and I filed objection that here already, before this also, Your Lordship, I have filed one application in Nangal Bibra police station itself, which was registered as 17 within bracket 8 of 2015, stating that 4 vehicles which has been taken by them, by forging my signature, they have changed the name of the ownership, of the vehicle. And that also case has been registered in Nangal Bibra only and still is pending as Nangal Bibra police case number 17 within bracket 8 of 2015. That has not been culminated till date, Your Lordship. So again I approach the Additional District Magistrate, Baghmara, that I have the grievances, my vehicle has been taken away and the name of the ownership has been changed fraudulently without my consent and my signature has been forged there. And in this regard, I have already filed the FIR against the, in this regard, in the Nangal Bibra police station. As such, the vehicle should not be released to respondent number 2, Your Lordship. The learned additional district magistrate kept the order of 28/9/2018 in abeyance, wide order dated 4/10/2018, Your Lordship. On 4/10/2018, the learned ADM was pleased to keep the order in abeyance and directed the IO to complete the investigation as quickly as possible and find out how the vehicle has been transferred. And in this regard, Your Lordship, I would like to bring to page number 13, Your Lordship, of the petition. Annexure A3, Your Lordship.
Page 13.
Page 13, Your Lordship. Annexure 3. Annexure A3.
Yes.
I may be allowed to read, Your Lordship. Your Lordship, order dated 4/10/2018. CR put up today. Seen the petition filed by Sri Rakesh G. Momin, son of Sri Sunil N. Sangma, resident of Kusim Kolgore, PO and PS William Nagar, East Garo Hills District, Meghalaya, praying for revoking the order passed by this court on 28/9/2018 in connection with another related case, Nangal Bibra PS case number 17 within bracket 8 of 2015 under section 467/34 IPC and pending this court. The learned counsel for the petitioner has referred to the above mentioned case pending in this court, stating that the Honorable Court had passed another order on 28/9/2018 releasing one vehicle truck bearing registration number AS18A 1771 on Jimma to Sri Dilip Kumar Chaudhary of Jogigappa, Assam. Next para, Your Lordship. In this connection, the learned counsel has brought to the notice, if this court, that the said Nangal Bibra PS case number 17/8/2015 under section 467/34 IPC was registered on the basis of the FIR filed by his client Sri Rakesh G. Momin, where Sri Dilip Kumar Chaudhary is an accused, and the vehicle AS18A 1771 is one of the seized vehicle by Nangal Bibra police. He has further stated that the investigation on the case is at the progressive stage and giving the seized vehicle AS18A 1771 on Jimma to accuse Sri Dilip Kumar Chaudhary at this stage will jeopardize the investigation. Therefore, the learned counsel has submitted to the court to revoke the order passed on 28 September 2018. The learned PP has submitted to the court that instead of revoking the order, Honorable Court may keep the order passed on 28 September 2018 on abeyance until the IO has completed the formalities of investigation. On considering the submission of both the learned counsel and PP, the court is of the view to pass an order the keeping on abeyance of the execution of the previous order passed on 28/9/2018 until further order. In the meantime, the IO of Nangal Bibra PS case number 17/8/2015 under section 467/34 IPC shall expedite completion of the investigation. The said seized vehicle shall be kept in Nangal Bibra police compound. This order was passed on 4/10/2018 by Sri C.N. Sangma MCS, Additional District Magistrate, South Garo Hills, Bagmara, Your Lordship. Against this order, respondent number 2 has gone approach to the District Magistrate. And District Magistrate had set aside this order, the order dated 4/10/2018. District Magistrate set aside the order, while his order dated 9/10/2018, Your Lordship.
Yes. Please continue.
Yes, your lordship. So lordship, here, like, after setting aside the order of the learned ADM, DM has released the vehicle to the respondent number 2, where I have already filed the FIR that respondent number 2 has forged my signature and changed the ownership of the vehicle. That is my contention, your lordship. Now here, your lordship, I would like to bring to the honorable court that whether the DM has the revisional power or appellate authority of the ADM. Whatever the order has been passed by the ADM, whether the DM can review, can revise. No, your lordship. Why? Because the additional district magistrate and district magistrate on par, your lordship. On par. They are equal. Whatever the cases has to be decided by the district magistrate or district judge or session judge. Same power the additional district judge or additional session judge or additional district magistrate has, your lordship. For that, your lordship, I would like to bring to the honorable court on section 3 of CRPC, your lordship. Section 3 of CRPC. Or table under subsection 4. I have also mentioned in my synopsis also, your lordship, in page number 4. The table has been mentioned in my synopsis also on page number 4. There, your lordship says.
What does it say?
There it says, your lordship, that the court of session or sessions judge or chief judicial magistrate is equivalent to district magistrate or additional district magistrate, your lordship.
Where is that table?
Table in section 3, after subsection 4, your lordship, one table is there where the Arunachal Pradesh, Mizoram and Meghalaya has amended state amendments, your lordship. There is state amendments. Under the column of state amendments, Arunachal Pradesh, Mizoram and Meghalaya, where it has been amended, and table says that the court of session or court of sessions judge or chief judicial magistrate are district magistrate or additional district magistrate, your lordship.
Where does it say additional?
Your lordship?
Where does it say additional? This Arunachal Pradesh, Mizoram, Meghalaya says court of session or court of session judge or chief judicial magistrate, district magistrate, equivalent
District
to
magistrate, your lordship.
But there is no.
Here one additional district magistrate, I think it has been left, because in other table, next Nagaland table.
That Nagaland, we are not concerned with that.
Nagaland table is there, your lordship, the district magistrate or additional district magistrate. It's same, your lordship.
Nagaland is not, see.
Yeah. Here also it's same only, your lordship, because. Because another is mentioned, but here I think it has left, because that has been notified by notification 25 of 74 dated 2nd April 1974, your lordship. That I need to be.
That is.
Yes, your lordship. So my
anyway.
Yeah, yes, your lordship.
My
My contention is that, your lordship, that the additional district magistrate and district magistrate has the same power, same hierarchy, your lordship. Whatever the cases triable by the district magistrate can be triable by the additional district magistrate also. The way we used to try, the way the sessions judge and additional session judge has the equal power, your lordship. Whatever the cases can be triable by district session judge, same cases can be triable by the additional session judge also.
That is, you see, that is known to everyone.
Yes, your lordship.
But what you have to, you see, in a legal proceeding, you have to refer to certain rules, certain acts, certain regulation to bring out your your point.
For that, Your Lordship, my synopsis, Your Lordship, page number 7. Page number 7, I have annexed the Assam Autonomous District Administration of Justice Act 1960, where Your Lordship, the additional deputy commissioner is being appointed, Your Lordship, by the state government. And here, Your Lordship, section 2 says, Your Lordship, I may be allowed to read, Your Lordship.
This act is applicable to Meghalaya?
Yes, Your Lordship.
Where
Yes, Your Lordship. All the additional district, additional deputy commissioner and all, even judicial also till now, they are being appointed under this act, Your Lordship.
Where is the provision which says that this act is applicable to Meghalaya?
This is Assam, Your Lordship. This is Assam here, but it has been adopted by the Meghalaya and still the notification.
Where is that?
Right now, I don't have the notification, but the latest notification also has been.
There must be.
Yes, Your Lordship.
By the adaptation, act.
Yes, Your Lordship. That,
1972, 1973.
It will be 1973 Adoption Act. Yes, Your Lordship. That I can bring, Your Lordship, on the next date if
You should have been
permitted.
prepared.
For that, I have not prepared, Your Lordship. I will bring that.
Because whenever you are assailing
Yes,
the
Your
power
Lordship.
of any authority, you have to bring out from where the authority is derived,
Lordship.
how it is relevant to the facts and circumstances. You can, if you are quoting Assam Act, you can also quote the UP Act or Maharashtra and say that it's applicable here.
Yes, Lordship. But till now also, Your Lordship, whatever, like even our
We know that
district and session judge or additional district and session judge being empowered as a additional deputy commissioner to try the cases in tribal area, that also is they are being appointed under the Assam Autonomous District Administration of Justice Act 1960, Your Lordship. And that notification also I have, but unfortunately I have not brought today. So for that, Your Lordship, any date may be given, I can furnish, Your Lordship.
Yes, so we'll continue the hearing on Monday then.
Maybe Tuesday, Your Lordship, if possible.
May I please, Your Lordship? Lordship, the synopsis which my learned friend is referring to, I was not serve a copy of this.
I will
here.
supply copy, Your Lordship.
If the same may be, and other notifications which my learned friend will be referring to, if that can be given, supplies where I.
See, Mr. Kumar, you have to first bring some relevant authority to this court as to what are the powers of the DC, the Deputy Commissioner, or the District Magistrate, Additional District Magistrate, how they have derived the power, what are their functions, as far as, administration of justice is concerned, criminal justice is concerned, all those things has to be...
Right, Your Lordship. I
had
1937 also.
I had given you a hint. Perhaps we are governed by the
1937, yes, Lordship.
It's there. So
I will bring that, Your Lordship.
So, Mr. Chaudhary, Tuesday.
It might be heard on Tuesday, Your Lordship. I have no issues regarding to that. My similar flair with my learned friend would be that a copy of the notification might also be provided to me.
You have to give him a copy. Whatever you're relying on.
Right, Your Lordship, we will supply.
You have your local counsel here.
I have my local counsel there, Your Lordship. He's present before the court.
I will
supply. Who is appearing? Right. So you give him a...
Right, Your Lordship.
Heard learned counsel for the petitioner. After the matter has been heard substantially, the learned counsel has submitted that he may be allowed to refer to relevant authorities, including notification as regard the power or the functions and duties of the district magistrate, as well as that of the additional district magistrate in the administration of justice in the state. On prayer made, The same is allowed. As prayed for this matter on 16 May for further hearing.
Deeply
Deeply obliged, Your Lord.
Thank you. Much obliged.
Second call, item number 13.
Your Lordship, the last question
Yes.
is could ask me to produce the if any order pertaining to this my appointment approval, as because counsel for the defendant was saying that's only the resolutions, body of the resolution they are giving the approval. Other than this, there is no approval for the appointment. So in my case, Your Lordship, I have confirmed from my client. So even I have gone through this appointment letter. So in the appointment letter is clearly written this appointment is given. This in my petition I have given annexure 1, page 23. May I read, Your Lordship? This is the office of the Secretary, Politicons, Secondary School, then dated 21st September 1994. Number such and such. In person, the resolution number 1 adopted by the MC in its meeting dated 7/8/94 as approved by the Inspector School, West Garfield Tura, by memo number such and such dated 29/94. Sri Imam MD Abu Alam Abdullah, PhD Rural, is hereby appointed as science teacher, Rural, with effect from the date of his joining in the school at a monthly salary to be given subject to the ability of the fund and grant. So, you see here, there is a clear approval from the authority.
Yes.
So, there
what does royal mean?
This is the science, royal means is science. That point of time it was called as well as just
Okay, so science.
And it was approval.
Where's this? Have you annexed this approval?
So you will have this
of the
approval
inspector
letter.
school?
This approval, if any letter, it will be with the managing committee, not with me.
Yes, of course, will be.
And this is the reference is here.
Mr. Chaudhary, you are the managing committee.
Yes.
Do you have a copy of this?
Yes, I got it along
No,
with this
the approval by the inspector of school.
Yes, it is mentioned, Lordship.
It is mentioned, but where is the copy of the
copy of this?
You have it, did you?
Copy of this, then I'll have to ask for Lordship.
No, you have not annexed it in your.
No, I have not given because they have already given. So as such,
Because,
when we answered in our affidavit in opposition, we have relied upon that. Therefore, we have not given additional. We have started in our affidavit in opposition only with the resolution by which his service was removed and one Samir Raza was regularly appointed. From that point, we have started in our opposition.
And that subsequent appointment was also approved by.
Yes, Lordship. Yes, Lordship.
There is no such approval.
Yes, there is. There
This
is in the body.
inspector like that is not given.
That is another thing,
Yes,
because
it is-
at
okay,
that
you
point
can-
of time, Your Lordship, I think I do remember that in Garo Hills, those resolutions and appointment and other respect of the schools, the development plan, teachers or promotion, these and that, on the body of the resolution, the inspector is to return it, but marking the letter number. Your Honor will find when we in our annexure 1, that at the foot the government letter number is mentioned there. Affidavit in opposition, if Your Honor goes through annexure 34, annexure B.
You are respondent.
I am respondent for 9, 10, 11.
9, 10, 11. 59.
Yes, Lordship, page 34. Your Honor will find at the left side, approved, inspector's seal and signature. And
Oh, this one.
will find in page 36 at the footnote the approval letter number. That is SWG MC AH
Where is it?
6795, signature dated
Just say
26.
someone.
That was the style of in Garo Hills at that point of time, Lordship.
But if there's a reference here, so copy of this letter must be there with you.
No, copy of, because
this
letter,
number SWG.
they used to send from the school inspector when after approval is sent. This is quoted from there, from the office itself. When it comes the approval, Your Lordship, in that form it comes. Because this question arose in other respect of other schools. In Dolu High School, I do remember I had also conducted a case on behalf of the lead petitioner, and there the school committee also submitted before the Honorable Court that this is the way the approval at that point of time was given by the inspector. Now, of course, it has been when the Honorable Court's order was there, that then they are now.
Who's paying for the state?
Pardon?
Who's paying for the state? State is also a party here.
State is also a party.
Where is?
State is not here.
Oh. These things have to be, confirmed by the state as to the manner in which the approval was given. What is there in their records?
Sir, Lordship, I will refer that to the secretary or the headmaster, and meanwhile, Lordship may confirm it.
Why is the state not here?
Someone is there.
This is a 2015 letter. We cannot just keep it. Mr. Sengupta, he is not here. Maybe he's in the other court.
I didn't see him today.
Yes, miss, can you please help us? Can you please help us? Can you just look for Mr. Sengupta if he's somewhere around?
Yes. You know, Shani, ask in the government section. That's why she's quite new working with me, Lordship.
Oh, she's already.
Not yet finished her.
You ask, where's Mr. Sengupta?
She can. Government section, please wait. Yes, Lordship, I have deputed another friend here in front of us.
He's not available.
Is he there? He left. Oh, he's left.
I didn't see him today. I didn't see him today.
No,
Sorry?
I've not seen, of course.
I didn't see him today.
So what we'll do, Mr. Devnath,
Then Tuesday?
You start.
We'll start this Tuesday. By this time, if they have the copy. Because I've given this, there will be clear copy of it, as because they have mentioned.
Bye. So Tuesday. Tuesday then.
Next Tuesday.
Yes. But no more adjournment. See, 2015 matter we cannot afford to.
Worship.
When the matter came up for hearing, the state respondent is found to be unrepresented. it is to be noted that this is a long pending matter, and though the other parties are ready for the hearing, but for the absence of the state respondent, the matter could not proceed. Accordingly, as prayed for by the parties, this matter is adjourned for the day. List the same on 16 May. It is, however, made clear that no further adjournment will be allowed in this matter. Thank you. So whatever you have to clarify, whatever you have to, you just check whatever. You
Yes,
do it.
today itself I
Get it done, so that we will not waste time. Sometimes in the course of hearing, something is not there, then you ask for time, then you get instruction, all those things.
No. Today itself I do, Lordship.
Please.